If you are here to file for a civil protection order, also known as a CPO, there are a few things you should know. There is no court fee to file for a CPO. You may want an attorney to represent you in court, but that is not required. You may want a victim advocate to accompany you through the process. The advocate cannot practice law, but would be present to provide support and safety planning. State law requires that the respondent, the person you are filing against, must be either a family or household member, a spouse or former spouse, your child's other parent, or a dating partner. According to the Ohio Revised Code, the courts can issue a CPO only where the respondent poses an immediate and present danger, which includes threats of bodily harm or actual physical harm. The order can last up to 5 years and would stop the respondent, again, this is the person you are filing against, from having contact with you. This means no phone calls, text messages, in-person contact, or emails, and they cannot have someone else relay a message from them. If the respondent is your child's other parent, the magistrate may add an exception to allow the respondent to have parenting time with your child. You should carry your CPO with you at all times. If the respondent violates the order, you can call the police, and the respondent may be charged with violation of a protection order. That is a criminal charge. The CPO process has 2 steps. In step 1, you will go in front of a magistrate and explain why you are requesting a CPO. This hearing is called an ex parte hearing because the other party, the respondent, won't be there. If the ex parte order is granted, the magistrate will set a second court date called the full hearing within 7 to 10 business days. The Montgomery County Sheriff's Office will serve the respondent with the ex parte order and notice of the full hearing. Note, if you get an ex parte order, it will not go into effect until the respondent is served with the CPO paperwork. It is important to have a good address, either home or work, for the respondent. Step 2 is the full hearing, where both you and the respondent will be allowed to testify to tell your side of the story. If the respondent agrees to the order, it is called a consent agreement, and there would be no need for further testimony. If the respondent does not agree to the order, the magistrate will consider the testimony and will mail out a decision. This may take a few weeks. The ex parte order will remain in effect until the magistrate issues their decision. CPOs are not criminal cases. However, you should know your rights in criminal cases. Marcy's Law protects Ohio crime victims' rights, including the right to be notified if the offender has been released from jail or prison. Victims can call Victim Information Notification Every Day, or VINE. To register, call 800-770-0192 or visit vinelink.com. Marcy's Law also provides you the right to be present and heard at all public proceedings, to speak with the prosecutor, and to have a victim advocate present. If you need a safety plan or support, call the Domestic Violence Hotline at 937-461-HELP to talk with a victim advocate. You can remain anonymous. Remember, you are not alone.